All right, guys, happy Thursday. Welcome to session two of about 12, where we are going to walk our way through the closing process, the contract to closing process. Our theme, as you guys know, this quarter is see you at the closing table. That's like some of the best words, right? See you at the closing table. Contract to closing table mastery for Florida Realtors. So we are walking our way through the closing process, making sure that we have a very detailed understanding of what happens after we go under contract and the file is now with the closing agent. This is important. You guys do this all the time. Your clients do this once every, maybe every 17 years. Many of you, your clients is gonna be your first time. Make no mistake, sellers, there are first time sellers. It's so funny that dynamic. We always think about first time buyers. Well, guess what? That first time buyer at some point is going to be a first time seller, and they're going to have some questions about the process from the other side of the table. And so for that reason, it's important for you to think, oh, because they're a seller, they're more sophisticated. They have questions too. And so for that reason, like I indicated last week, we're going to walk our way through this process to make sure that you as Florida realtors, the guides, as we mentioned last week, the quarterbacks of the closing process, that you are fully aware and you understand yourself so that you can explain to your clients this process from contract to close, right? I've had an opportunity to already meet one new face. If there are any other new faces in the room, welcome, welcome, welcome to our Thursday live webinar. My name is Ray Cole Jackson. I'm a South Florida real estate attorney. A little bit about me personally, just to give you a little bit of background about me. As I learn more and more about all of the new faces that join us each week. I am originally from Florida. I attended the University of Florida. I always do this. I always say go Gators because this little rivalry we have with this little small school, Florida State. So I always say go Gators. I flew out to California where I got my law degree from Santa Clara, and I was the founder of the Real Estate Law Society out there at Santa Clara University School of Law. Came back home to Miami and got my LLM in real property development from the University of Miami School of Law. So secondary, she says stay on my Seminoles. Secondarily, go Canes. No Seminoles there. Marissa, you know I love you, but this is where we part ways. I am a proud licensed Florida realtor. Got my first real estate license in California, actually. And I am a licensed mortgage loan officer in Florida. So when we come into this room, guys, we talk all things real estate transaction, right? We have a 360-degree conversation about the transaction process. For those of you who've been with us for a few weeks now, you know that what our theme is for this year is transaction mastery. We're going to dig more into that later this month and get more into that theme because we're cooking up some um, some content around that transaction mastery, right? So it's important that you understand the transaction process. Now, this quarter's content is powered by title experts. We're talking about title and closing, and so this quarter's content is powered by title experts, our title insurance and closing firm. On the screen there, you see our contact information. Many of you, we are happy to say we've had an opportunity to work with you, to continuously work with you over the years. For those of you who we have not had an opportunity to work with before, we look forward to the opportunity to working with you. We close all of Florida. We close all of Florida. If I were to list for you all the office, the remote office locations, satellite locations, we would be here for a while. Just know that I get this question all the time. Well, can you close? I have a listing in this county, and my buyer is here. We close all of Florida, right? So there's no property, no location in Florida that we cannot close. And then many of you have had buyers that are national, right? They're in other counties, well, or in other states. There's ways to do that. There's mobile notaries, right? There's remote online notarizations for sellers. Of course, there's your mail away. And so the point is, there is no distance between us, between our closing tables and your next transaction. All right, no distance. Just always just let us know if you ever have any questions. All right, all right, all right. Your handout. You guys know the drill. Grab your handout, purchasereadylabhandout.com, purchasereadylabhandout.com for today's handout. Good to know. Yeah, for sure. So here I am, like you guys, you assume that your clients know certain things, but they don't. So I can't assume that you guys know that. So any transaction in Florida, we got you covered, right? All right. So let's get into today's discussion. The flawless handoff. So we talk about today we're focusing on the intake portion of the closing process. And so we're looking for a flawless handoff from the realtors to the closing team, right? So many of our, hey, Luckner, most of our trainings we're 50-50, right? We're substance and then we're process. We're substance and process. Transaction mastery. You have to know the substance of it, and then there should also be a systematic way of delivering that substantive service, right? And so our workflow today is the intake process, right? So day one dictates day 30. It does. So what that means is our goal is simple. We want to manage client expectations, communicate effectively with the closing team, and keep the transaction moving slowly, smoothly from day one, right? Day one dictates day 30. The way you do one thing is the way you do everything. And so we don't want chaos. We want the file to come into the office smoothly. Once day one dictates day 30. If the handoff is rocky, right? If information is left out, then the closing team is left trying to fill those gaps later on, possibly even at day 30. We don't want that. What does that look like? Day 30 looks like, you knew for whatever reason there was some friction, and we're going to talk about this. You knew, well, let's not even go that deep. We're going to talk about it later. Let's say you know that the buyer is in another state, and for whatever reason, there's no reason for, or you know that they'll be traveling as the agent, you know that they'll be traveling. And so now we get to day 30, day 28 in closing, and we're like, all right, so we'll see you when you get here. And they're like, excuse me, I'm in California. You're where? When was someone gonna when was someone gonna tell us you're in California? Right? You need to be here, or we would have needed to coordinate a notary to get out to you, so on and so forth. So the point is, day one dictates day 30. So we want a smooth and flawless handoff from day one, right? To the closing team. So, oh, we went a little far. The mission is mastering the first steps. We want to identify key steps, understand how the closing file is open, what information is reviewed first by the closing team, what critical deadlines we're looking at. It's, with regards to intake, we're looking at deadlines concerning the searches being ordered and back into the office. And then we're setting client expectations. Setting client expectations to let them know here's what to expect when this file is handed off to the closing agent for closing. Again, you'll be surprised that there are some customers, again, that for whatever reason, they may be leery about having new conversations with a new set of people, or again, they're leery about some of the information that is requested from them. And so forewarned is forearmed, right? And so as you're working with your customers and you're preparing them for that handoff, because you're learning this process today, you'll be able to include this in your consultations, right? Or include this in your transaction management from contract to closing. We want to make sure that we manage expectations. Again, the first steps, they're going to dictate the final outcome. If the client comes in rocky, if the client comes in feeling like they're getting information after the fact, if they come in feeling like, well, nobody told me that, or I didn't know what to expect, then that feeling can sometimes linger into the closing. So we want to get ahead of that. We want to make them feel comfortable. Remember, guys, there's a lot of folks that are contacting them all at the same time, right? It's particularly a buyer. They're going to have Of course, they're going to have the lending team. They're going to have, they may be communicating with an appraiser because they have to pay for their appraisal. Of course, they're going to be communicating with an inspector, right? And so right, if you have a transaction coordinator, there's going to be a lot, the homeowners insurance representative, a lot of people, movers, a lot of people that they're communicating with. And so the better we can give them a clean and defined pathway and give them some insight as to who they should expect to hear from, why, how, and when, then it eases some of the confusion. All right. Also, better teamwork. When you've forewarned the customers that this is the next step, this is what you're likely going to be asked for. Number one, we don't get delays in them providing the information because they already knew. And if they had any questions about the information that's going to be requested, then those questions are answered earlier, right? So it stops those delays. And then again, better teamwork, right? Now there's no friction between the customer and closing because again, they knew that this information was going to be requested. So with intake, of course, the first communication is generally going to be from one of the agents, right? We'll learn later on about who selects a closing agent, right? And whichever customer selects a closing agent, of course, it is going to be their agent that initiates the communication with the closing team. The listing agent, of course, that is the realtor that represents the seller. The selling agent represents the buyer. At intake, be prepared. The information that's going to be requested of you, besides your client's contact information, is going to be the information related to your brokerage and you yourself individually. What I would recommend for you, because every closing agent generally should ask you for this information, I would just have a one pager. Here's my information, right? Your name, again, it's going to be your brokerage, what you see here on the screen. It's going to be your brokerage name, your brokerage address, your brokerage phone number, your name, your phone number, your email address, and then, of course, you're going to need to confirm for the closing agent your compensation. We don't need your compensation agreements because we don't enforce those. If a closing agent is asking you for that, you really shouldn't give it because that's a contract between you and your customer. And they're not enforcing your contracts. So why are they reviewing your contracts? That particular contract. The only reason that we obviously receive the purchase contract is because we need that data, that information to do our job. But remember, I told you guys in the last training, we do not enforce your agreements, right? We receive the information, we facilitate that transaction, but we don't enforce the terms of your agreement. So with that being said, if you were in the habit of sending your buyer's brokerage agreement or your seller's compensation agreement, you don't need to send that. You don't need to send that. All right. That information will be provided. It should be provided in a very clear intake form anyway. All right. So that information is collected from both the listing agent and the selling agent. And then, of course, you would also provide your client's contact information. Guys, believe me when I say this to you. If you already have this available, many of you, well, some of you might work with a transaction coordinator. I would suggest that all of you do. But your transaction coordinator should be in the habit of providing all this information at the outset. Once this file is sent in to closing, your transaction coordinator should already send your information. They should send your client information. And if you represent the buyer, they should be sending the lender's information. And we're going to talk about the lender in just a couple slides. All right. So again, this information is not going to change. So instead of you having to, provide it every single time, different formats, likely if you just send this form, it is going to allow you to avoid having to submit that information again. All right. All right. So we've touched on the realtor intake. Let's talk about the buyer and the seller. One thing that you should be aware of, we don't get this pushback all the time, but we get it often enough that it should be included in this training. If you represent the seller, You need to make sure that the seller is aware that their social security number will be requested. It must be collected because it is used to facilitate reporting the sale to the IRS. The sale of real estate is a reportable event. And so when it is sold for taxing purposes, it's reported to the IRS. The way that it's reported to the IRS is by attaching their social security number to the transaction. Again, it doesn't happen all the time, but it does happen sometimes where customers push back on this. What you should know and what so that you can incorporate this into your guidance of the seller, you already know why it's requested. Here's what they need to know if they refuse to provide it. If they refuse to provide it, now we fall into FERPTA land. FERPTA, we're going to talk about more further into this webinar series, but high level FERPTA, FIRPTA, stands for, it's an acronym for Foreign Investment in Real Property Tax Act. Foreign Investment in Real Property Tax Act. If the seller will not provide a social security number as a individual, EIN number as an entity, then we must assume that they're foreign. And when they're foreign, you guys know what we have to withhold upwards of 15% of the sales price and send that to the IRS. It just creates a whole Pandora's box if the sellers already have a social security number, right? So for that reason, you guys now know why the social security number is collected. You want to make sure that you're able to explain that to your sellers so that we avoid FERPTA. And again, this is something that we need to know at intake because if we do not know this early enough, then now we are um, searching for this. Now we're spending our time discussing FERPTA or preparing for FERPTA when it's not relevant. All right. All right. Now for the buyer, we do not need the buyer's social security number. We do not need the buyer's social security number. Right? We do not need the buyer's social security number if they are an individual. We do not need their EIN number, employer identification number, if it's an entity. We do not need that number because again, we're reporting a sale, not a purchase. Right? Now, I'm not even going to talk about, you guys know a couple weeks ago we talked about fencing. It's a whole nother animal for the purposes of today, particularly because that has been appealed, right? We talked about that a couple weeks ago. Fencing has been appealed, and so that's not even being enforced right now. Not enforcing fencing. We're not enforcing where it's a cash transaction. We have to collect this additional information. All right. So on the screen you see just a comparison between what's collected from the seller when they're an entity, such as an LLC or a corporation, versus when it's a natural person. There's two different intakes. If it's an entity, we're looking for their state of incorporation, their EIN number, and then we're also collecting the name of the natural person. There's contact information for the natural person that we're collecting. The natural person is going to sign on behalf of the entity. Okay? If the seller is a natural person, then all we're collecting is this information. If the seller is an entity, 123 Main Street LLC, okay, we're collecting information about 123 Main Street LLC, but then we're also collecting information about the person who's going to sign closing documents on behalf of 123 Main Street LLC. They have to be prepared for that. One other bit of information that we're collecting will be their operating docs. So again, this is just a reminder that with regard to the buyer, we're not collecting a social security number or EIN number for a buyer. Okay. When they're transacting as an LLC or a corporation, again, we are going to collect the entity data. This is just another way for you to visualize this. There's going to be data collected about the entity and then data collected about the human. Once we get those two, then that seller is closing ready. Now, why do we do this? Corporate structure, they add legal layers. So we have to confirm who has the right to sign on behalf of that entity. From that, we're going to look at Sunbiz, where businesses are incorporated in Florida. And then we're also going to, if necessary, we're going to ask for their operating agreement, the operating agreement of the LLC. The operating agreement of the LLC lets us know if there are multiple managers or multiple members of the LLC. That operating agreement lets us know who has the right to sign on behalf of that LLC. If the LLC does not have an operating agreement, and per Sunbiz or whatever state that the entity is incorporated in, if there's multiple members, multiple managers, well, everybody has to sign. Everyone named here has to sign, because we are not able to determine who can, if there's only one individual or two of the four or three of the four, if we're not able to determine that using the operating agreement, then everybody has to sign. All right. So that's intake of the buyer and the seller. Let's talk about intake of the lender or the financing team. You guys should know that there's a difference between a broker and a lender. The difference between a broker, a mortgage broker, and a lender is a mortgage broker is an intermediary. They help the buyer shop for suitable loan products. They do not lend the money. They're the go-between. They're the go-between the buyer and the lender who will ultimately fund the transaction. Because there's a difference between the two, we're going to be doing intake for both the mortgage broker and the lender. And with those two, we're generally collecting the same information. For a mortgage broker, we're going to collect the broker's name, address, phone number, and then their individual name, phone number, email address. For the lender, we're going to collect the name, address, phone number, the loan officer that works for that lender, name, phone number, and email address. You can have a transaction where your buyer is working with a lender and no mortgage broker. You will never have a transaction where your client is working with a mortgage broker and no lender. Because again, the mortgage broker pairs them with a lender. When we get into the conversation about financing 101 for realtors, we'll go into more conversations about the difference between the two, which is better or the same. But you should know this. Again, you guys are this transaction mastery, right? You're going to be able to have a conversation with your client and say, when you meet with their financing professional, is this a mortgage broker or is this a lender? Okay, it's a mortgage broker. Who's your lender? Now, of course, we use the term interchangeably. We say broker or lender interchangeably. But for the purposes of learning, you should know there is a difference. All right? And again, if you represent the buyer, when the file comes in, you might not know who the lender is, and that's fine. But at least provide contact information for the mortgage broker. Someone in this financing, on the financing team, right? All right, so that's the lender intake. Now, that's the information intake. Now let's talk about intake of the earnest money deposit. You should know that while a deposit can be made multiple methods, they generally are check, money order, and wire transfer. Wire transfer is most common. Notice cash is not here. If you're working with a closing agent that's accepted cash, put an asterisk next to that name, okay? All right, is check, money order, wire transfer. And most common is wire transfer because the closing agent knows that that is good funds. When the earnest money deposit is made, the escrow agent, the closing agent, is going to send out to everyone an escrow letter. The escrow letter is written confirmation that the closing agent has received the buyer's escrow deposit. All right. With this being said, you should prepare your customers that a wire transfer is the most common and most likely. I'll tell you, for title experts, we only accept wires. We do not accept checks. We do not accept money orders because checks can be what do you call it? Not chargeback, but you guys know the word. It's never happened to us. It has happened to someone I know before. Post closing, they did a cancellation on the check post closing, and that buyer had to be sued. So for that reason, Marissa's shaking her head. So for that reason, wires only. Wires are good funds immediately. All right. And so now you guys also know if you run into a situation where the closing agent is telling you we only accept wires, you know why. And you know that it is not uncommon for that to be their requirement. Okay. Now, with that being said, pay special attention here, guys. Please. I'm not saying it as much as I used to see it, but of course, I don't see every closing. Be careful about wire fraud. How do you, as a realtor, ensure care concerning wire fraud? Number one, you should never deliver wire instructions to the buyer. Again, I don't see it as often as I used to see it. I think because brokerages have gotten involved in having this conversation with you guys, you don't handle wire instructions. You're going to make sure that the instructions are provided to the buyer by the closing agent only. Of course, if you have a situation where your escrow agent is different from your closing agent, that's pretty uncommon, but it's still a thing. I mentioned to you guys before, like if you're an agent with Kai's, Kai's is one of the brokerages that if you represent the buyer, they're going to have that buyer's escrow deposit go to their escrow account, even though another company is going to be the closing agent. With that being said, whomever is holding that escrow deposit, do not let those wire instructions pass through you. You never want the buyer to even get into the habit of thinking that wire instructions could possibly come from you because you do not want them to, because that's when they could possibly become the victim of wire fraud. You want your buyers to be trained to expect wire instructions and communication concerning wire instructions to only come from the closing agent. One person only, one source only. All right. So how does wire fraud work? And I'm going to try, and I hope I'm going to be able to explain this to you guys in a way that you can succinctly understand this because I've explained this to some people before. You guys have probably seen the wire instructions go out with the last two digits left off. That does not prevent wire fraud. It doesn't. Wire fraud occurs when the hackers, they intercept communications and they send fraudulent wire instructions. They send out fraudulent wire instructions to the buyer, right? Fraudulent wire instructions to the buyer. So wire fraud happens when the hackers are able to get to the buyer. So it doesn't matter if you put your last four, that doesn't do anything. That doesn't do anything to prevent it. The only way we can prevent it is if we create a cage around the buyer, but you're not gonna be able to do that. You're not gonna be able to create a cage around the buyer so that no communication comes to them. I mean, honestly, anything is possible. They could possibly get wire instructions via text message. Things are happening. Of course, they have email, right? Possibly someone calls them because you gotta think about it. The way they're getting these fraudulent wire instructions is because the hackers are sitting on someone's communication. They're sitting on your email, they're sitting on the buyer's email, they're sitting on the closing agent's email, they could be sitting on the listing agent's email. They could be sitting on the transaction coordinator's email. So they're just sitting watching this communication. They intercept it and then they send out the communication to the buyer, right? Now the fatal error is when the buyer blindly trusts the email and sends their wire to the fraudulent account, which unfortunately in 2026 we can do a lot of things, but it is nearly impossible to pull back in a wire. You can cancel a check, you can even cancel a money order. The bank can cancel a money order, but a wire, Once it's gone, it is nearly impossible. There's 99.9% chance it is never coming back. Okay? So, this is why we must make sure that our buyers have caution. We don't want to scare them because, there's thousands of wires going out, millions of wires going out every day just fine, as long as they have this care. All right. So we want to train them that from the moment they receive the wire instructions, they want to verify um, the wire instructions, that by always calling the closing agent at a known number to verify the wire instructions verbally, not via email, but verbally. All right. Um, it would not hurt for you all to have in your signature block, similar to what you see the closing agents have, a warning to the buyers that you will never send wire instructions. Wire instructions come directly from the closing agent. Always call and verbally verify wire instructions before sending a wire. All right? You will never get a wire from me, or wire instructions from me. Even in your buyer consultation, have them sign an acknowledgement that they will never receive wire instructions from you. Right? We want to make sure that they're like, this is serious. Don't just, and including saying, it's just gonna be the same wire instructions I used when I made my earnest money deposit. It could be, however, don't assume that. You're gonna make sure that you only follow the instructions that were provided to you. The wire instructions are gonna go back out to them at closing for them to wire their cash to close. Get your buyers in the habit of don't say wire instructions. When you receive wire instructions, call and verify them. All right? All right. So final warning. I see your question, Idiana. I'll respond to them at the end. You guys, if you have questions, feel free to drop them in the chat. So final visual. Closing agent provides the wire instructions to the buyer. Realtor does not provide wire instructions to the buyer under any circumstances. Don't do it. Not your job. Right? All right. So now we've proceeded in the escrow deposit. The next and final part of intake is ordering the searches. You guys learned last week the job of the closing agent, which is to manage escrow, title, and escrow, right? Escrow we just talked about. Title, we need to make sure that at closing we are going to issue clear title, insurable title to the buyer and the lender. In order to do that, we're going to order 4 searches, sometimes just 2, depending upon the property type, sometimes 3. But these are the 4 primary searches that are ordered by the closing agent. Notice we don't order an appraisal. Yeah, put that out there. Title does not order the appraisal. Of course, we do not order the home inspection. You guys learned last week that the title insurance policy that's issued at closing does not insure the structure. We're not insuring the structure. We're insuring the land that the structure sits on, but the structure itself, we're not insuring, right? Because potentially the buyer could knock that house down and build 3 houses. Now, does that change their insurance? No, because we are insuring the land. That's why we insure the legal description. We insure the land that the property sits on. All right. So these are the 4 searches that we order at intake. Title commitment immediately. Title commitment is going to evaluate what's recorded against the property. We're going to make sure the title commitment is going to tell the closing agent, okay, title experts, there are 2 mortgages. There's a recorded code violation. And unfortunately, it looks like there's a deed that was missing someone's marital status that needs to be resolved. I'm like, oh God. When you see anything concerning a deed, take a deep breath. Because that means there's something back in the chain of title, and hopefully we can get in contact with the folks who signed that deed. All right. All right. The next search we're ordering is the lien search. The lien search is the looking at the municipal record of the property. The municipal record of the property. It's going to show unpaid taxes. It's going to show unrecorded code violations. The lien search can show code violations that are not reflected on the title commitment. Again, we're going to go deeper into this later in the session, but know that from a title clearing perspective, title is responsible for clearing what's on the title commitment. We utilize the lien search specifically for utility bills. Outside of that, anything else that's reflected on the lien search is for informational purposes only for the title agent. However, the buyer and the seller, at the advice of their realtor, the seller can agree based on the buyer's request. What is the language we're looking for? Seller will close out all unrecorded code violations, unresolved permits prior to closing at seller's expense. Because we know contractually the seller is not responsible for addressing anything on that lien search, except for if you add the additional term language. And of course, we're going to go more into that later in our training, but I'll make sure to mention that every time we hit the lien search. The third search that we order, if the property is managed by an association or a condo, is the estoppel. The estoppel. All right. The estoppel is going to give us, it's going to let us know the balance of the account. It's going to let us know that if there's any violations, and if there's any costs that need to be collected from the parties at closing. The estoppel we must absolutely comply with. Again, we're going to talk more about this later, but just to give you guys a high level understanding, if this estoppel comes back and says that there are violations on the property, sidewalk needs to be pressure cleaned, uh, door needs to be painted, we have to ensure that those violations are resolved before closing, because this estoppel is tied to the title commitment. If the property is located within an association, there's going to be a requirement on the title commitment that says comply with all requirements of the association. Well, the way we know the requirements of the association is to then order an estoppel. The fourth search is a survey. The survey lets us know that the property and its related attachments, a fence, a shed, that they all sit within the boundary lines. Easements, encroachments, it also tells us. It's going to give us that report, right? A survey is ordered on every property except for a condo. Townhouse, surveys ordered. Of course, single family residence, surveys ordered. Survey is going to be ordered on every property except the condo. So those are the four searches that are ordered. Now, to give you guys some insight, once they're ordered, timing. We're talking about timing. Timing, the title commitment is going to be ordered immediately. Generally, the title commitment can be returned to us within about 3 to 5 business days. If a title commitment takes longer, there are some title issues that the examiner is having to sort out. But generally, the title commitment comes back first, and it comes back again within 3 to 5 business days. The survey takes about 5 business days. That survey generally is ordered as we get closer to closing, just because it takes 5 business days, and we want to make sure that the parties do not incur costs unnecessarily. The estoppel, it takes about 2 weeks, because they get about 10 business days. The estoppels take the longest to come in. For that reason, if you, as a listing agent, you know that the property is located within an association, this is information that you absolutely should provide to the closing agent when the file is open. Don't make them have to go search for the contact information for the association. And if you know specifically who the estoppel should be ordered from, let's say you know that the association has a management company, then provide the management company information. All right, the estoppel takes the absolute longest from a timing perspective. And this is good for you guys to know when you get out there and you have, maybe a cash closing, or maybe it's finance, but a quick closing. Well, that's when agents call, Ray Cole, can you close this deal in 14 days or in 10 days? One of the first questions, is there an association? If there's an association, They get about 10 business days, which could look like 14 days. All right. Lien search, those generally about five to 7 business days. But the reason you see this pushed all the way out to 14, there are some municipalities that take a long time. Riviera Beach being one of them. My West Palm Beach agents, Riviera Beach takes a very long time to get their lien search back. All right, so just keep that in mind. Marissa, that was a true outlier you had. So now we know about the searches and the timing of the searches. To wrap up, the special matters that you should disclose to the closing agent when the file comes in, because there's no way to know except you tell them. You want to disclose these issues to the closing agent the moment the file is open. It will give the team time to plan for logistical hurdles. What are some of the special issues that we see at closing? Power of attorney. You need to say as soon as the file is open, my buyer or my seller intends to utilize the power of attorney. Why? Because that power of attorney needs to be reviewed by underwriting to confirm that it is sufficient. If it's the buyer, it also needs to be reviewed by the lender's underwriter to confirm that it is sufficient. If it is the seller, it needs to be reviewed. If the seller is available, the power of attorney is not already executed, I'm going to tell you right now, Title Experts is going to require that seller to sign their title documents at the time the power of attorney is executed. You can utilize the power of attorney for trailing documents, but if you're going to take the time to sign a power of attorney, which has the same requirements of signing a deed, which is signed in front of a witness with a notary, well, let's just go ahead and put your title documents in there because the power of attorney can be challenged, right? So you want to let the closing agents know, you want to let the closing team know right away whether or not a power of attorney is in play. Language or communication limitations. We live in a multicultural society. If your buyer or seller has challenges with the English language, you need someone that's bilingual, speaks another language, just let us know, right? So that we know that ahead of time before someone just starts sending all types of emails and you're like they don't even understand what you're saying, right? They speak a language more different language more fluently than English, so we should know that. Technical limitations. If your client is not tech savvy, including we have customers who just simply don't have an email address. Yes, in 2026 we have customers that do not have an email address. Please let us know that. Now I would let you know that from an agent perspective, that's not something that you should get to closing with because you have documents that need to be signed by an individual. They should have a contact, someone that they trust that can receive emails on behalf of your customer. I mean, I have yet to encounter, unless that customer just absolutely refuses to have someone to utilize an email address on their behalf. I cannot think of any circumstance where you should not be able to explain to a customer that an email address is going to be needed or you're going to really just slow this process down. There's too much communication via email for a customer to not either have an email address themselves or have someone who can navigate emails on their behalf. All right. No conflict amongst the parties. Oh my God. If you have buyers, sellers that are quarreling, at odds, do not agree, cannot be in the same room, should not be on the same email communication, wave the red flag immediately so that your closing team knows how to navigate that. And that happens much more often than we would like, but it's real life. Don't try to hide it because it's going to come out. It's just going to make the closing agent, it's going to impact your closing. Because closing agents going along thinking, oh, they're getting my emails, they're gonna comply, and then finally we get to further down the road, and they're like, we'll see. They haven't given me my shoes out of that house yet. I'm like, what? Your shoes? You'd be surprised the commentary we get, right? And lastly, double closing. Now, this is not indicative of everything we should know, but this is just high level, some of the things that commonly come up, some of the special issues that come up. Double closing, guys, please do not. I don't care how phenomenal it looks, how sassy it looks, how Instagram worthy it is, TikTok worthy it is. Do not plan to close your seller's sale and purchase the same day. That is a disaster waiting to happen. Do not. There's no reason for that because most times it doesn't happen. So even if your seller's like, oh yeah, we need to close on our sale so the closing agent can wire the funds to the closing agent for our purchase. If y'all need a script around that, let me know. I'll send you some objection handlers. That is a disaster waiting to happen. That rarely happens the way that they see it happening in their head. So do not draft your contracts that way. Do not time your closings that way because that rarely happens. All right. All right. So high level intake. That's step one. Day one to the first 48 hours. The first 48. You guys heard that show before. The first 48 of your handoff to the closing agent. This is what you should know, right? Now, of course, this is your handout that you guys received from the handout link. Hold on to this. It's your high level. It's your high level of day one into day two. Now that you guys are very clear on, I'm saying very clear, I'm going to assume you're clear on what's happening behind the scenes at your handoff. It is the intent that is going to create better, a more streamlined communication with the customers, more streamlined communication with the closing team, right? And you guys are more clear on why this information is being requested. All right, let's talk about it. Questions. Let me see. I see some questions in the chat already. So I'm going to start. Um, Idiani asked about crypto. Currently, we do not facilitate crypto transactions, particularly because they're not frequent enough to set up to maintain the infrastructure that would be needed to facilitate it. Back during COVID, when crypto was a very hot and popping topic, that was a different situation. But I can tell you, even for the transactions that did make their way to the closing table, by the time it got to closing, the buyer they converted the crypto to fiat currency and they closed in currency anyway. So doesn't wire process fall into the title responsibility side? I'm not sure exactly what you're asking there, Idiana. Um, Sending the wire instructions, yes, that's on us. So again, that's what we talked about. Um, what do we ensure for the land? We ensure clear title. That was last week's training. If you guys missed last week's training, you should definitely. I think last week's training was a good eye opener for realtors to really understand what the closing agent's responsibility is as it relates to the closing process, and particularly closing with clear title and why the closing agent asks for the information that they do and what their responsibility is. So if you missed last week's training, then you want to catch that replay on YouTube. Got that. On YouTube. So if you go to YouTube and you look up Purchase Ready Lab, you should see the link. Also, Dominica, you should have received an email after every session. Well, the next day, there's an email that goes out with the link to the replay. Should be, yeah. So if you didn't get that email, so watch out for that email. And if you didn't get that email, you can always just go to the YouTube page and type in Purchase Ready Lab, and the replay is posted there by Friday. All right. All right. Again, recap for those of you. Let's see. Hold on one second. Does this Apple? Yes. Yes, Bernadette. That's a good question. all associations such as townhomes and condos. So any property that's managed by an association, whether it be a townhouse, single family home, or condo, yes, we are ordering an estoppel. Also, and we'll talk about this further. I'm glad you asked, and because it comes up, it does come up all the time. You can have vacant land that is managed by an association. We literally had a closing before. Title commitment came in. Title commitment asked for an estoppel. And of course, for whatever reason, the seller did not realize, I don't know, or I don't know, whatever case, they did not have a rider on their contract. So that created, this kind of loops into the contract class. That created an issue because the buyer was not anticipating being managed by an association or paying association fees. So again, see how it all loops together? See how it all loops together? Go ahead, Luz, you have a question. You can come off mute and ask your question. Or type, but it'd be quicker if you come off mute. Go ahead, Deanna, while Luz is typing, you can speak.
Good morning. Can you hear me?
Yes, ma'am.
Good, thank you. I actually have a question. There are some communities, including where I live, that have what is known as a civic association. All it is supposedly for events and things of that nature, but it is known as the Imperial Point Civic Association. If that ever comes up on, does that ever comes up on any of the titles that you have dealt with, where you
Yes,
have
they
to
have.
contact
Yes, they
the
have. They have.
president of this community, Betty
Yes.
Shelley?
Yes. The reason why it comes up is because if the civic is if you have to, for example, pay a
No,
fee, if you don't,
it's totally volunteer.
well, if it's voluntary,
Volunteer.
then it's not going to come up.
Okay,
Any
perfect.
any association that has rules and requirements either around how you're going to manage the property or requiring you to make payments into, a fee for their management of the community or a fee for their providing of a service, then yes, that's going to be recorded against the property, and we're going to see it at closing.
Thanks.
Okay, my question, can you hear me?
Yes, ma'am.
Okay, my question is about the HOA too. I have a listing and a potential buyer, but the buyer is refusing to sign the homeowners association disclosure. And my question is, can we move forward with the offer if he doesn't sign that?
Absolutely not.
So there is nothing. If he doesn't sign that, there is nothing. Okay.
Absolutely not. Yeah. Absolutely.
Okay, and now just one more question is, what is the document that the buyer's agent have to submit to for his commission?
Just the intake. The intake form
Is
it
it the
requests
FF or this GG?
submit to the closing agent.
No, to me,
Oh,
he's gotta send because the seller is paying his commission, the buyer's agent commission. So
okay.
he's asking me what the form is he's gotta submit. Is it the FF or the GG?
That's a good question. So
To get paid, yeah, commission.
Compensation agreement.
so what'd you say, Luckner?
I think the form she needs to fill out, it's a compensation agreement from seller to buyer, broker, That's the
But
form you need to fill out.
which one is that? I was told FF and then I was told GG, and he's
No, no, no. I
asking me.
like Luckner answered the right question. Give me just 1 second. Give me just one second.
Okay,
Grab my binder. Give me just one
okay.
question. It's like a couple part answer. Number one, it is the seller's compensation agreement.
Yes,
Is the
sir.
first thing, right? That's the first thing. Now, what
Yeah.
you're asking about the rider to attach to the contract so that it makes it a contingency in the contract. So
Yeah.
GG, you have the rider that says that the seller and the seller is going to sign a compensation agreement. And then you have the rider that says that the seller is going to provide a credit. Of course, if they're providing compensation, then you're not going to sign the credit addendum. You're going to sign the compensation addendum.
Yeah,
So
the compensation addendum. When he's asking me which one he's got to put in there.
the
What is
compensation, not the credit, the compensation addendum.
compensation? Okay.
Hmm. Right.
Okay.
Not the credit addendum, the compensation agreement, addendum.
Okay. Okay. All right. That was it. Thank you very much.
So FF is the credit addendum.
Okay.
GG, right? GG is the compensation addendum.
Okay. So the GG is the right one. Okay.
Yeah.
Thank you very much.
No, very good question. I'm gonna let you guys know too, because Candace sent a question last week, and we touched on this, but I feel like we need to have another. She said, "What is the purpose?" Candace, she said, "Explain to me again the difference." Did you say it was the difference? What would you?
Benefit. What's the benefit?
What's the benefit of Rider GG? Right? It was GG specifically, right?
Correct.
Um, we gotta have another conversation about that. My position hasn't changed, but for Candace to ask the question, and Candace is on the call all the time. Um, there's just a deeper conversation we can have about that, so you guys can understand it. And I know someone mentioned maybe 2 weeks ago that I have shared with you guys some language around those agreements that gives it even more teeth. So I need to share that again. Just because in the last training, I'm gonna say this and let you go because some people are like, what is she talking about? Just because, and I'm not scaring you, the riders, yes, they make compensation or the credit a contingency in the contract, but that's still a contract between the buyer and the seller. Therefore, the buyer and the seller can subsequently agree to remove that addendum, and it does not remove the fact that the buyer needs to be the buyer's agent will be paid. It's just that now the buyer's agent remedy is different. They're having to address that collection of compensation from a different angle, if that makes sense. So again, very high level. We need to have another conversation about that because again, it was a very good question and needs further clarification. Last question, Mike, can you give me some contact information for an insurance company for a condo? Oof. Um, is he still on here? Chris is the only name I would think of. JR, message my with Chris's contact information is who I would think of. Um, any other questions? Any other question? No? All right, cool. Today was again, wasn't gonna be tough. All right, Luck, see you later. I told
Thank
you guys
you.
today should be easy. Wasn't gonna beat you up too bad. It's 101. Time to go. I'll see you guys next
Hmm.
Thursday, all right?
Bye bye.
Oh,
Thank
Thank you
thank
so
you.
much
you.
for
See you
thank you for
later.
everything.
No,
Thank you.
for
It's a good
sure.
was a
Good to
great
see
class.
y'all.
Thank you.
All right.
Thank you, Rico.
I fall
No
asleep a little
problem.
bit, but that's kind of
You say you feel sick?
no, I fall asleep a little bit.
Oh, jeez.
I fall
Lord.
asleep because I was tired.
You need to
So
rest.